Okay. What's the time? Okay, we might as well kick it off. Sorry, we were running a few minutes late here. Hi, my name's Carl van der Merwe. I am with a firm called LCR Capital. We're a investor and basically an advisory and investment company, helps families gain residency in the US and in Europe through the investor visa. We're here to discuss today the EB-5 investor visa as a means to get permanent residency in the US. And we're also going to devote some time to the tax implications, getting your green card and planning around that from a South African perspective. I'm very pleased to be joined with by two fellow South Africans here, Leon Versveld and Hugo van Zyl. Leon is a senior immigration attorney based in Kansas City. He has his own practice there, and he's helped many South Africans over the years move to the US through various visas. He's an expert on EB-5. In fact, I think Leon has probably moved or immigrated more South African families to the US than any other immigration attorney. Prior to Leon establishing his practice in the US, he worked in South Africa and was an advocate of the High Court. Yuhu, pleased to be joined by Yuhu as well, who's a cross-border tax specialist. He runs his own tax practice out of Cape Town and advises expats and immigrants on cross-border tax matters and pre-immigration tax planning. Yuhu also estate planning and advises businesses looking to expand internationally on both tax and exchange control. Just as a sort of admin matter, there is a ability for you guys to pose any questions. We'll keep them for the end and answer all the questions you have. This will also be recorded, and we'll send you a link to the webinar after the presentation. With that, I'd like to hand over to Leon to run through the EB-5 program. I'll then have a discussion on our current investment project, and then I'll hand over to Yuhu to discuss the tax implications of getting a green card.
Dankie, Karel. Thank you very much. My name is Leon Versveld. I am born and raised in South Africa, been in the United States for about 20 years. Hugo is my partner. Now, not the Hugo that we see on the screen, Etienne Hugo, and the both of us immigrated to Australia and the US respectively over 20 years ago. So I've been in the United States exclusively practicing immigration to the United States. Etienne Hugo has been practicing immigration to Australia. We'll be doing a webinar next week with regards to some variety of options, but we are here today to talk specifically about one of the many options to come to the United States. This is not necessarily anything that everybody can afford, and I know in South Africa the economy is pretty tight right now, but this is definitely an option worth considering if you have the ability to do so, because it's really a one-step process getting into the United States as a permanent resident, short from marrying a US citizen. So I'll have Carl just kind of slide through this program. We're going to talk about the EB-5 program today, and EB is just kind of abbreviated word for employment-based. So this is the fifth preference category. There's obviously a few others above that, EB1, 2, 3, and 4. But we'll focus today specifically on the EB-5, which is the investor program. Carl, I'll just have you kind of slide through all of those. This was kind of created in 1990. So this program has been in place for quite some time now. And it only really became popular in 2008 when the economy in the United States took a dive, and companies in the United States went abroad to go find some foreign investment. So this investment is basically tied to an immigration benefit that gives a permanent residency to the investor, his spouse or her spouse, and kids under 21. This process is administered by the Department of Homeland Security's agency called the USCIS. Funding is brought in US dollars from abroad. It is supposed to create 10 jobs, and its objective is to attract high net worth individuals to grow the economy in the United States in specific, what is called targeted employment areas. We'll go to the next slide, Carl. So there is recently a proclamation that was brought out by President Trump that I thought that I'll just kind of quickly put in here, because quite a few folks have said, hey, look, we heard that Trump is basically putting a stop to all immigration. Well, we have the proclamation on the screen here for you that you can access afterwards too, but specifically EB-5 was carved out as an exemption to this process. And really, when you look at it all, there's really a small amount of people that was affected by this proclamation. And it's mostly for folks who are out of the country, waiting for immigrant interviews that are coming over here to work here permanently. And in any event, most consulates across the world is in any event closed. So this 60-day stop on inbound permanent immigration for employment-based 1, 2, 3, and 4, didn't really have that big of an effect, as well as the diversity lottery. But for purposes of our discussion today, the EB-5 was specifically carved out as an exception to this proclamation. Coral? Next slide, Coral. All right. So here is the question as to why you would want to consider EB-5. This is kind of a win-win situation. I think if you understand, your benefit, which is obviously inherently tied to the immigration benefit that it brings, I think it is also a good idea as to why there is some kind of a benefit to others. Obviously, the US wins because you are coming over here to, as a foreign investor, to invest in a specific area where there is high unemployment and where in certain criteria is met, where a specific economic need needs to be met. So the US economy wins because you're coming over here to inject some capital along with some other investors from around the world, as well as it is incumbent upon you to prove that you're going to create 10 jobs through the investment regional center of your choice. The other folks that wins is the companies that are actually that goes through the process with immigration and asking immigration to vet them as a regional center in order to attract high net worth individuals to invest in their projects. So here's just a few of companies that is listed here that has raised EB-5 money in utilizing this. So the benefit to them is they get relatively inexpensive capital from high net worth individuals to, typically fill that mezzanine financing that they have a need for in finishing their projects, and tie that in with an immigration benefit so the company wins. And last but not least, obviously you as the investor, you also win, because this is tied to, this investment is tied to, as I said before, permanent residency to the United States and giving you opportunity. Now, a lot of the clients that we have portfolios not necessarily just in South Africa or elsewhere in the world, and quite a few of them would diversify their portfolios and put money perhaps in an EB-5 investment in order to create opportunity. So they would have some real estate portfolio, maybe some stuff on the US stock market, and so on and so forth, and maybe some stuff in the UK. And then sometimes what they would do is they probably just move some of their portfolios around in order to create opportunity for them and their family coming to the United States. All right, Carl, next slide. So you can just kind of list all of these, Carl. Well, here is the number one requirement is that you need to find a regional center of your choice. And I'll talk just briefly about the other EB-5 option. And that regional center needs to be authorized by USCIS. You can find all of these regional centers on USCIS's website, these that are active, in order to determine whether or not the regional center that you are submitting, going to invest in is still active today. You are then required to invest $900,000. Now, this is higher than what it was last year. Last year in November, the regulations changed wherein they increased the minimum threshold for investment. It used to be $500,000. It is now $900,000. The TEA areas definitions also changed a little bit for some of the regional centers. But that was kind of the big change that happened in November. And we had a surge of folks file before that November deadline in order to meet that minimum threshold. Today, it is $900,000. So you would invest $900,000. The regional center that you will invest in would have already gone to immigration ahead of time and shown through an extensive business plan that their project is going to create 10 jobs per investment. So that is already done through the regional center that you're investing. Now, just on a side note, the other part of this EB5 is also called the direct investment. It's not something that we stand still on today, but it is also possible for you to do a direct investment through $1.8 million, so a little bit more money. And then you can do it literally anywhere in the world, anywhere in the United States. You are not limited to doing it in a targeted employment area, but you would still need to be responsible for the creation of the 10 jobs as you go on. We have seen that and we do both, but we have seen that the folks who are doing a direct investment, it becomes really, really tricky because of the extensive wait time on adjudication of that investment. So it is conceivable if you do a direct investment that you can wait 3, sometimes even up to 4 years before you can get permanent residency due to the delay in the adjudication of these kind of cases. And that becomes tricky when you have all of this money invested in the United States and you're not allowed in the meantime to come over here to look and manage that investment. And so for that reason, a lot of people have chosen to do, for half of the money, do it in a regional center where it is a turnkey kind of investment. You are not necessarily, you are not involved with regards to the day-to-day operations. And these regional centers have already gone before you to get regional center status from the United States Citizenship and Immigration Service, wherein they have needed to show that 10 jobs are created. So the next thing that we will stand still on as your attorney would be the source of your funds. Just go back one more, Carl. The source of funds is probably one of the more crucial parts of this whole process, where we would need to sit down with you individually to determine what the origin was of the funds that you're going to use to invest in this money, into this regional center. And last but not least, this money that you're investing, we have to show that it's going to be at risk. There was one regional center at some point in time that I think had some folks denied because there was some bonds involved. The money cannot be guaranteed to be returned. However, you need to, just like any other investment, feel very comfortable with the investment that your capital is going to be returned to you. And last but not least, no criminal violations. We oftentimes see, thank goodness, not too many times, that by the time we will ask you ahead of time if you've had any other, crossings with the law. And sometimes we'll have some folks as we go along and police clearances starts coming up, that we would see a violation, maybe just a small violation. And when we confront the investor or the family member about it, they said, well, we didn't think it was relevant because the matter was expunged. That doesn't matter. I think, since we have an attorney-client privilege relationship, it is very important from the outset that you and your family be upfront with us and be honest during the whole process. All right, Carl, next one. So here's a few of the benefits. Carl, you can just list them all. But I think one of the more important things, is that you need to understand that unlike, my partner in Australia, wherein there is a point system, and if you are at a certain age, doesn't matter how much money you have, you disqualify for going to Australia, that the US do not require age. They do not require any kind of education. And these are some, or health benefits or whatever the case may be. And these are some common questions that we oftentimes get from our South African investors, as saying, hey, look, I'm a great entrepreneur, but I never went to school, to university. Or, hey, I'm kind of like 80 now or 70 now, and I don't know if that will qualify. You also don't need to necessarily even speak English. I think the only time that English would become relevant is if you want to take up the citizenship test later on. But the proficiency of most South Africans is more than third grade level that they test you on a naturalization application in any event. The other benefits, obviously, here, I think from what we've seen our entrepreneurs hop on, is the great access to financing. Interest rates in the United States are significantly low right now. You can, get a 30-year mortgage on a house, for less than 4% over 30 years. And then obviously access to the great health system over here. I think one of the most important benefits that we have seen utilized from most of our investors is the benefit for their kids. Oftentimes you will have your kids probably come and study in the United States in any event because of the lack of access to universities in South Africa, due to some changes, and or just due to some higher quality of education. And if you're going to spend the kind of money to bring your kid to the United States to come and study over here, you'll be paying the highest tuition that the universities have to offer in the United States, on top of obviously room and board at an exchange rate of 18 to 1. So what a lot of folks do is they utilize this for their kids, because as your kid comes to the United States to ultimately study, he will be a permanent resident. As a permanent resident, he would not pay international student fees. In fact, those fees will be somewhere in between in-state tuition and international student fee prices. That is significantly lower than you would otherwise pay. And in some cases, depending on what university you go to, you could even conceivably pay, we have calculated in the last time about $500,000 in saving that you can make depending on the university. The other thing that we've also found with one of our South African investors is they wanted to have their kid go to one of the top universities. I think it was Yale or Harvard. And their chances of getting in there was significantly lower because they were coming as a foreign student, but because they were turned into permanent residents, their chances increased in getting access and admitted to that university. So university costs in of itself is a great access to give opportunity to your kid, because once he graduates or she graduates from a university here, the likelihood of them wanting to stay here and get opportunities for jobs in the United States is over 90%. There's probably no chance that they would want to go back to South Africa based upon some opportunity or lack of opportunities over there. And so what ultimately happens is that the investor will probably just gift the money to their kid. The investor may not be ready to make the move to the United States yet, or they have other plans. And so the kid would ultimately become a permanent resident. 5 years later, after being a permanent resident, they will become a citizen. And then we can look at, making the mom or dad a citizen, a permanent resident through sponsorship of their child without any kind of investment. But I think these benefits is worth standing still on, because I think it would tie back to the why on why you want to do utilize this program as an opportunity to come to the United States. All right, Carl, the next slide. We'll keep going through those benefits. I think I just kind of talked a little bit about some of these already, so you can just kind of skip over to the next slide as well, Carl. All right, so here's basically how it works. So upon engagement, when we've identified the regional center of your choice, we would go and make sure that these regional centers obviously still complied with US regulations, and will vet the job count and be in consultation with you with regards to the quality of the regional center. One thing that I can say here upon the application, picking a regional center that is exemplar versus a regional center that's not exemplar, is that we have seen that the exemplar projects is getting adjudicated much faster than those that are non-exemplar. And I'm happy to say that the project that we're talking today about and that Carl has is exemplar. Here's the difference. The exemplar project is a regional center that's gone to immigration and said, hey, look, would you vet us to become a regional center? Immigration has said yes, but then they've gone back to immigration being a regional center and say, rather than frustrating the investor with regards to questions that you may have subsequently for the investor and or for us as a regional center, why don't we just get that out of the way right off the bat? And so they would do another dummy filings with immigration, and immigration would, through this exemplar process, just really kind of vet and ask questions with regards to the business plan, maybe an update on some of the job creation, maybe getting something else as it relates to from the economist, in order to make sure that once the applications are filed under exemplar status, that the adjudicator who's reviewing that exemplar packet is really just focused on the investor and the source of funds. But once we file this application, it will take about 18 to 22 months in order for us to get an adjudication of the 526. In order for us to get that filed, you have to have had your investment in place with the regional center. I would need a receipt from the regional center that says your money has now been invested in the regional center. We'll prepare your file, and get all the documents we need as far as your source of funds is concerned and the details of you and your family. In filing this case, 18 to 22 months is still kind of an average of an adjudication on how long this takes. However, we have seen some kind of a little bit of a change here recently in March, April. Immigration has come back and said, we are tweaking our policy a little bit on how we are adjudicating EB5 cases. Typically, they would do a first come, first serve basis. But because of some backlogs in countries like China, India, and Vietnam, they have said, look, it doesn't help us to adjudicate the guys from China who filed 5 months, 6 months before you, and spend time on their adjudication, because once we approve their case, they're still going to be sitting around and waiting for a visa number to become available. So they've kind of moved things around a little bit. And I'm happy to say South Africa is not in retrogression. So there's visa numbers available for South African investors, which means that they are adjudicating your case filed today ahead of a Chinese national who may have had his case on file a year ago or longer. And that is also, we have seen speed up some of these adjudication processes. We've had some recently approved in the likes of 8 to 10 to 13 months, and that's huge. But I think from an average point of view, you should still bargain on the fact that this is probably going to take 18 to 22 months. If it happens faster, at least that is the unknown that we have that we can play around with regards to moving forward. But once we get this approval, two things happen. I'll obviously notify you. And then internally, USCIS will send this approval to the National Visa Center, who's the agency that will be dealing and preparing this case for consular processing. That processing, obviously in COVID, seems to take a little bit longer because of the closure of some consulates. But that process typically takes about 3 to 6 months. And once they are then done and all your background checks and everything is done, they'll schedule an interview at the consulate, and we will be in contact with you again with regards to preparing and what to expect for that interview. And we'll put you in touch again with the regional center just to make sure that you are updated with regards to what's currently going on in that regional center, so that you and your family is prepared for that interview. It's a pretty straightforward interview. You will get they will keep your passports and then send your passports back via DHL to the address that you've told them to send it to. And that immigrant, you will then get an immigrant visa sticker in that passport that is good for 6 months. Now, within that 6-month time frame, you will then be required to make a first entry into the United States. Coral, you can keep going. So upon that first entry into the United States, your green card will be activated, and it will be a conditional green card. The green card is conditioned upon you needing to have made an investment in the United States, and that investment remaining there to create the 10 jobs, and also to make sure that the economic impact is what was required and what was said right off the bat. So after that, right before that 2 years expire, we will then go back to immigration and file for the removal of condition. Coral, the next one. And so on the removal of the condition, all I'm really going to go show is the jobs were created. At that point in time, the hotel or the project that you were investing is probably already done. And we will go show the job creations was already done, but more importantly, that your money still remains invested. This is not the point where Carl and the regional center gives your money back. Once this removal of condition is done, your green card will then be a permanent one, and your green card will not be conditioned on an investment, meaning that that will also be then the time that you get your capital back from the regional center. This green card process, as you have gone through from that first entry into the United States, there's a parallel timeline that runs, which is a 5-year timeline, irrespective of this conditional green card. But the 5-year timeline starts running, and within that 5 years, you'll be eligible for US citizenship. Now, at least currently today, South Africa still allows you to take on dual citizenship. You would need to notify the South African government ahead of time, and they would need to give you permission should you want to keep your South African citizenship. And then as a South African, when you enter South Africa, you'll need to use your South African passport. And when you and with your American passport, you obviously can travel in and out of the United States and everywhere else. All right, Carl, next slide. All right, so here's just a couple of scenarios. One of the ones that I've already talked to you guys about. You can just list them all there, Carl, but the typical one that we get is a family unit. They're trying to figure out on how to bring the whole family unit over. So this will just be mom and dad and kids under 21. Now, in some cases, it's very important that we file the case before the kid turns 21, because once the child turns 21, they will be on their own, and they would need to find an immigration benefit on their own. So it's very important to note that these applications has to be filed, before any child that you want to bring along with you is under 21. We've also had scenarios under which, we've had children over 21 where father or mom, give them the money in order to do the investment themselves. And it's a scenario where I talked about before, where we have the child become a permanent resident, 5 years later become a citizen. And as a citizen sponsoring a parent, it makes it relatively easy and straightforward to sponsor in the parent without any kind of investment. And that's about a 6 to 9 month process to get your parents over. Also on that process, with a permanent resident, with a US citizen child, sponsor parent, it doesn't matter if the parent can speak English or not. It doesn't matter how old the parent is, and it also doesn't matter what the education of the parent is. All right, Carl, next slide. All right, well, our firm has over 20 years of experience in this process. We've been in the immigration business since coming to the United States, and we practice exclusively in US immigration. Right before I got into immigration, did a variety of litigation here. And that has, I think, helped us springboard with regards to being creative and knowing how to put these cases together. We've helped over 300 families obtain permanent residency through the EB-5 process, not just through South Africa, but a variety of other countries, including those from Brazil, UAE, and so on and so forth. And with our American partners that we have partnered up, I know firsthand, I travel to South Africa quite often. This time I was supposed to be there, in fact, just the end of this month, but due to COVID, unable to travel. But I go to South Africa quite a lot, and I know what the circumstances are over there, and with the fluctuation of and the changes and the fluctuation of the rand. And I can understand firsthand how important it is that once you make this decision, that you make a solid decision that will almost guarantee you and your family coming over. Visa options, typically if you have the stomach to stomach it as an alternative, is definitely an option, but it becomes very tricky when you do some visa options, just because of the fact that a visa has a lifetime of a year, 3 years, and you need to continue to renew it, and so on and so forth. Last but not least, I saw some questions pop up. There has been some rumors and popping around from Politico and some of these other news agencies that oftentimes try to get out news fast but not correct. They want to get it out the first rather than making sure that it's vetted correct. So there's been some paper articles that have talked about them decreasing the amount again, increasing the amount of green cards that are available. I can tell you, I serve on the committee with IIUSA. This committee is a bunch of EB-5 immigration lawyers here in the United States that basically has a committee directly linked with Washington. And I can tell you firsthand, serving on this committee, that there is no changes on the horizon. Yes, there are some senators that don't like it. There's some senators that do like it. And so you sometimes get some guy who just wants to talk about one senator who doesn't like it. And then everybody gets up in arms about, oh my God, is this going to change EB-5 as we know it? The short answer, at least today, is no. I think EB-5, even in COVID year, is a great benefit to the United States for the obvious purpose. We have a high unemployment rate now. With your investment, you have to create 10 jobs. We welcome foreign investors like yourself. With investment like that you'll bring to the United States, there are companies who can benefit from that can also benefit during this time frame. All right, Carl, over to you.
Thank you very much, Leon. That was excellent. I'm just going to give you a brief introduction to our firm, LCR Capital, and then I'll talk a little bit about our current EB-5 investment project. So LCR is a investment advisory firm. We have 6 offices all around the world. I'm based here in Westport in Connecticut. What we really do is we help families gain permanent residency through EB-5, but also through the Portuguese Golden Visa, which we've entered fairly recently. We have over 800 high net worth clients from 30 plus different countries, and we've raised close to $200 million in EB5 capital. Last year, we had an excellent year as a firm. We ended up in the top 3 regional centers in terms of capital raised, and that was into 2 separate projects. There are a bunch of regional centers out there. Over 700 were registered as of March this year. Most of them are dormant. Very few of them have raised significant capital and have a track record. But we're pleased to see that we are one of the few that have. When LCR entered the EB5 market, 2014, 2015, they took a strategic approach to enter markets that were very undeveloped at the time, and not focus on China, which is where most of the EB5 participants were focused. And consequently, we've managed to build a decent market share in some of the fastest growing and largest EB5 markets. India and Brazil are 2 top markets, and we have a decent market share there. South Africa as well. South Africa is a relatively small EB5 market. There were 120 visas issued in the last fiscal year, but still it's an important market to us as a firm. Just to reiterate what Leon said earlier, these are the last available stats for approval times for your I5 to 6. You can see for South Africa in the first quarter of fiscal 2019, there were 22 I5 to 6 approvals. It's 100% approval rate, and the actual average approval time was just under 15 months, which is pretty positive, encouraging. I'd like to go to our project now, which is called the NFL's Hall of Fame Village. The NFL, or the National Football League, is huge in the US, and it's hard to overstate this. The NFL is by far the largest sports league in the world globally, dwarfs any other soccer league in Europe or South America, NBA, etc. It's, in terms of revenue, it is in a league of its own. Also has by far the highest viewership of any sport in the US. And the NFL every year celebrates their top athletes and coaches, the very best in the game, and inducts them into what is called the Hall of Fame. It's a huge honor. Only a few NFL players have been inducted into the Hall of Fame over the last 100 years since football has been played in this country. The actual Hall of Fame itself is located in Canton, Ohio, which is where the first football game was in fact played. In fact, a century ago. They're celebrating their centenary this year. And what we're doing in this project is raising capital to expand that facility in Canton, Ohio. This is a slide of what it looks like, well, a futuristic slide of what it will look like. The actual Hall of Fame at the moment consists of the museum, a state-of-the-art football field. There's various other sports complexes, etc., attached to that, and that was all completed in the last few years. There was a $250 million capital spend. We're involved in raising capital for phase 2, which is ongoing. It's just going to include theme park, 2 premium hotels, conference center, some retail, etc. And the vision really here is to transform this venue from very much a sort of a museum type experience to a more of a Disney-like experience for NFL football fans, and tap into that huge fan base in the US and bring people to Canton, Ohio. It already attracts about 1 million visitors a year, so it's already a very successful venue. But the management of the Hall of Fame have got great plans to expand on that and grow this tremendously. That all sounds great, I guess, but you know, the question really is, from an EB5 investor's perspective, it's a good project. And we believe it is for two main reasons. One, it's going to achieve your green card, and secondly, you will get your money back. From the first perspective, getting your green card, as Leon has mentioned earlier, this project is exemplar approved, which essentially means USCIS has pre-approved it. They've seen the documentation, and that box has been ticked. Also, this is a $150 million EB5 capital raise. So far, almost $100 million has been raised for this particular project. And half of those investors, roughly half, have already got their approvals, 100% track record. So there is a track record here in terms of getting approved, and getting approved fairly quickly. The job creation has already been met as well. Even if we do raise the full amount, there are already enough jobs for all those investors created in phase one of this project. It is in a targeted employment area, as Leon mentioned, which qualifies it for the lower investment threshold, which is currently $900,000. We believe you'll get your money back. And here the most important criteria is to make sure that the developer is a high quality, credible counterparty, because ultimately you're lending money to the developer to develop the Hall of Fame, and they have to repay at the end of 5 years. In this case, the developer is a group called the Industrial Real Estate Group, or IRG, founded decades ago by a guy called Stuart Lichter. He's a billionaire. But most importantly, they have a tremendous track record in EB5. They've raised over $350 million for various projects, and have repaid investors roughly 70% of that already, $250 million roughly, across most of their projects. And this slide just sort of sets out in greater detail their track record. Those are the 10 projects that IRG has raised EB5 capital for. They have fully repaid investors in 7 of those projects. And as you can see as well, they have 100% track record in terms of I-5 to 6 approvals, and I-8 to 9 approvals as well for those that have reached that stage. So we as a firm are very excited to partner with a high quality counterparty or developer like IRG. It's a tremendous opportunity to be involved in the Hall of Fame and the NFL as well. Particularly this year, as it's their centenary year, they're planning to have some significant celebrations around that at the Hall of Fame in Canton when the football season starts again, which is in the fall in the US. So it's tremendously exciting for us. With that, I'd just like to hand over to Juhu to maybe talk about the tax side of things and introduce himself. Thank you.
Good afternoon, Carl, Leon, and all the attendees. Thanks a million for the opportunity. So with this comes a big challenge. I think in world terms, America is seen as one of the most difficult tax jurisdictions, and it's a very complex system. And one has to understand that they use terminology that's a little bit different to ours, okay? So I don't know if you guys are following the question. Someone have asked me already about the automatic taxpayer status when you have a green card. What happens is that you actually get a tax number earlier than when you get the green card. When you get the green card, you are deemed to be a worldwide taxpayer. So it is indeed possible that South Africans can be a worldwide taxpayer, both in South Africa and in the USA. And very important is that in the USA, they have a rule that they will follow the treaties, but until you reach green card status. Then you have some options, but once you are a passport holder, then America takes note of the treaties, but they will not follow it for American nationals. So a South African living in the US, before he gets nationality, can avail to the treaty benefits in America, but he is better off to go and avail to it back home in South Africa. So Carl, the slide there at the moment, is that the right slide? Can I just quickly ask? Just go back. It's not, doesn't really, it's the slide is not showing on my side correctly, but don't worry too much about that. I'll make sure that I cover everything in there. Okay, right. So first of all, I also answered one of the persons who asked about financial immigration. So first of all, financial immigration doesn't exist. Financial immigration is a trade name. The process in South Africa is tax immigration and formal immigration. The first one being the tax immigration. The correct words in the tax law says to seize tax residency in South Africa. And you can seize tax residency on one of three ways. First of all, you break your ordinary resident status. Very, very difficult to do. And there's a lot of proponents who say that you do financial or formal immigration to do that. SARS has replied it's not adequate. You have to do much more than that. Well, today is not about that. The next step is you can do the 330 days. If you've been outside of South Africa, 330 continuous days. But you can only avail to that rule if you were not a born South African. So for most of us on the seminar today, born South African passport holders, forget the 330 days. It's not applicable to you. The one that is most applicable to people going to the US is then the treaty exit. In the definition of a tax resident in South Africa, it is a tax treaty that will make you tax non-resident. But the consequences of that, as you can see on the screen, is that you now will be paying a withholding tax on capital gains tax, and you may then have a reduction on dividends tax. Financial immigration is about, that's the Reserve Bank process, which is actually the Reserve Bank word for it is formal immigration. That is an optional process. Tax is a consequence. Formal immigration is an option. And by end of February 2021, this will be abolished. So that's where the hashtag rest in peace financial immigration comes from. So most of the people that are now thinking of applying or in the process of, you will probably not be able to do formal immigration, because one of the requirements of formal immigration is you must already have a permanent residence permit, that's a green card, to live in the other country and be able to give an undertaking that you will not return to South Africa in 5 years. So up to about 2-3 years ago, in that first temporary 1 year of your green card, they were very reluctant at the Reserve Bank to grant it to us because of the statistics that there's 100% success for South Africans. We have convinced them. So I've had clients that applied and got it in the first year, but most clients had to wait till the second year. So very important on the financial immigration, you can go to the next slide, thanks Carl, is that the financial formal immigration, it is something that you can try and consider, but don't worry about that too much. That slide that's in front of you at the moment, the most important part there is that I tried with colors to show you that the 330 days test only applies to people that became tax residents in South Africa on the physical presence test. You can flip to the next slide, thanks Carl. And also very important that in South Africa, we use the terminology physical presence test. The USA refers to it substantial presence test, and their tests are a little bit different. So there was a question earlier that asked me, how do you do the tax immigration into the US or the tax immigration with an E from South Africa? So we have to look at the treaty, and it's on one of the next slides, but I'll deal with it right now because it's probably more appropriate. The double tax treaty says you cannot avail to the treaty until you are paying tax in America on the worldwide basis. So in your first 3 years of being in the US without a green card, you probably won't need the double tax treaty because you'll only become tax resident in the third year after you've been in the US 31 days for that year. But most people doing the EB5 will probably only relocate to the US once they have the approval. So therefore, they will probably only trigger worldwide tax in America on receipt of the green card. But whatever route it is, now that you have American tax status and you're paying American tax on the worldwide basis, you can tax immigrate or cease to be a tax resident from South Africa, provided you meet the treaty rules. There's treaty tiebreakers to say, America claims you as a tax resident, South Africa claims you as a tax resident, which one applies? I won't go into the tiebreaker rules right now, but assume the tiebreaker says now America wins. Then you can go onto your e-file onto what they call the RAV. That's the static deal part of your e-file. And you can go and click. You do it yourself. No big process. Don't need to pay people a fortune. You go onto the RAV. You tick on the RAV that you are now an immigrant. And then on the right-hand side of that screen, which is not on today's screen, it will just ask you, what is the nature of your income post-immigration? So for example, if you have a South African business and then you just expand it internationally and you're keeping your South African business, you'll put salary income because you'll probably still be receiving money from South Africa. If you have sold everything, cashed out, and you've moved everything into America, then you'll just say post-session income, which means that there could be income in South Africa, but it would only be South African sourced income. Because the big benefit, once you've tax immigrated from South Africa, is that South Africa cannot tax you on a worldwide basis. So that immediately answers the question, what about this expat tax and EB5? So the minute you have been granted your EB5 status and you have your first green card, the temporary one, you can exit the South African tax system and you don't have to worry about the expat tax. What is very important, if you're one of those who kept a business in South Africa and the South African business still pays you a salary, that salary may or may not be taxed in South Africa. It all depends on the treaty. So that's very unique per person. I'm not going to go into that too much. Next slide, please, Carl. Okay. So there's the tests that you must apply to. So very important is that when you arrive in the US and you haven't got your green card status, you are a so-called alien. And you can also be an alien while sitting in South Africa and you invest into America. An alien is a very, very dangerous tax position for a South African. You must try and get out of that as quick as possible. You won't pay capital gains tax in the US, but if you would die having those assets in the US and they exceed $60,000 US, you can end up paying 40% FET, federal estate tax. Very important is the Americans, for aliens, do not have the option of spousal rollover. So how do we get out of that? You must make sure that you meet that substantial presence test. And that's a 3-year test. And then in your current year, you must be in the US 31 days. And then you look at the another 2 and 3, second and third year backwards, and you claim a third and 1/6 respectively. All of those together must add up to 183. So in a 3-year cycle, you must be in America for 183 days, of which the last 31 must be in the current tax year. And the US, unlike South Africa, if you then are in the US on the 1st of January and you hit the 1st of February, you become a tax resident back to the 1st of January. If you arrive in America on the 1st of April and on the 2nd of May you've been there 31 days, then they make you tax resident from the 1st of January, although you were not there. Okay, so the US is totally different to South Africa. But the minute that you have that alien resident or resident alien status, now you're taxed like an American, and you then have the 11 million estate duty or federal estate tax exemption. You can then also avail to the double tax treaty dealing with gift taxes and death duties, because there's a second treaty. So we have 4 treaties, big treaties with America. The one is income tax, and the other one relevant today is the gift and death duty one. Okay. In this period of your 3 years, you can elect earlier to be deemed to be a full American tax resident. And that is typically someone would do that, for example, if you are the parent of a child that went in. So the child is the green card holder and he is going to sponsor you. What often happens is that mom and dad starts advancing money to the family in the US, and they start moving their money out of South Africa. And the reason why they then move it out of South Africa is that they then escape our estate duty, and if they die, the Reserve Bank will not call for that money to come back to South Africa because the legatee, their son, is living in America. But now, although you as a parent at that stage is waiting for a green card, so it takes I think Carl will confirm it's about 5 years after you got your green card that they can start sponsoring parents. It means that for a 5-year period, you're at risk of paying 40% estate duty, FET in America, on $60,000 and above. So it's very important that you then elect to be an American for tax purposes so that you can escape and you have that 11 million estate duty. So a little bit of estate planning for those who, and that's why most of my clients, it's always the son or the daughter going to America, getting the green card, and then parents follow. We move the money out, and now we can, by electing to be an American taxpayer, get you out of the South African estate duty, and 11 million US dollars is a lot of money in South African rand. So they end up not paying any death duties. It's a way to preserve wealth for a South African family relocating to the US. Okay, next slide, thanks, Carl. So there's the rules that I've discussed. I'm not going to repeat them. It's just important. It's 183 days over a 3-year test, okay? And all days physical presence is counted. And then it's 1/3 of the days in the past, the second year, 2 years back, and then 3 years back, 1/6. All right, next slide. Thanks, Carl. It's just very important if you fail to notify the US tax authorities. So if someone asked the question, is there a formal process? You actually have to notify the US tax authorities of your change of tax status. And also very important, when you elect to be a resident, and even if you're a resident alien, when you're the green card status, they have the so-called foreign bank reporting, or FBAR. You have to notify America of all your foreign banking accounts. So they don't have an exchange control. You can move your money where you want to, but you have to report that to them. Also very, very important is that the states that you notified them that you are tax resident, or the day that you become American tax resident on a worldwide basis, you need to notify, you're obliged to notify all your South African financial institutions, and probably all those all over the world, that you are now FATCA exposed. So that in CRS or FATCA rules, we say you have an USA, Indicia or Indicia, which means that some of the banks in South Africa or financial institutions worldwide may ask you to leave them as a client, because not everybody wants to deal with you with a US obligation, because then they have to report you in terms of FATCA and CRS. Because remember, the unique situation is America introduced CRS, Common Reporting Standard, but they haven't signed up for it. They have their own system called FATCA. Okay, so once you have the tax status in America, remember to also notify not only SARS, but also all your financial institutions in South Africa. Carl, next slide. Okay, I've dealt with all of that. We could go to the next one. Okay, then one of the things that is very complicated in the South African tax treaty with America is that the definitions of tax resident in the treaty is stronger and overrides the law principles. And the treaty always wins. It trumps the local law. So for example, you can have a South African sitting in the UAE. In terms of our treaty with the UAE, he's ordinarily resident in South Africa, tax resident in the UAE in Dubai. He is now applying for his EB5 and he gets granted the green card. He can then avail to the South African US treaty, although he is tax resident in the UAE, because the tax treaty in South Africa says, with the US says, you can avail to the treaty benefits, provided you are ordinarily resident in South Africa. And ordinarily resident in South Africa is until that day that you're absolutely sure you can avoid coming back to South Africa, you have the intention not to come back to South Africa, and you have reduced your footprint. So it's very important. When the son goes out first, when the parents follow, and they're the sponsored Americans, until they have green cards that are permanent, it's very difficult for them to say that they will never return to South Africa. So they remain ordinarily resident in South Africa, and they can avail to that treaty for as long as they want to. Can go to the next slide. Thanks, Carl. Okay, now we're talking about the exit taxes, and that's the capital gains tax that one of the participants asked me about. So the consequence of becoming tax resident in the USA and solely tax resident in the USA, our unilateral tax law in South Africa says the day that you become a deemed tax resident of America only because of the treaty, that day or the day before, you are deemed to have sold all your worldwide assets to yourself at market value. You are deemed to have sold the day before you become an American. So the Americans don't have the right to tax you yet. Only South Africa has the day before the right to tax you. You are deemed to sell all your assets to yourself at market value. So you're paying capital gains tax, maxed at 18% at the moment, on the unrealized gains. There's a few exclusions. The most important exclusion is any immovable property where the title deed is in your name. Because in South Africa, for tax purposes, a company that is a property-rich company, a property company, that share is also a movable property, but that's not excluded. On the property companies, you're going to pay exit tax, but on the house that's in your personal name, you're not going to pay exit tax. Also excluded from exit tax is cash held, doesn't matter the currency, South African life insurance, and South African retirement funds. Those will not be subject to the exit tax. If you are, for example, an optometrist and you're a partner in a South African partnership, the assets within that partnership, what we call the permanent establishment assets, that will also not be subject to exit tax. They will then, SARS will get that tax when you exit the partnership or when you die, whatever comes first. On the immovable property, the title deed properties, they will now introduce a withholding tax. And if you sell your house and the selling price is above 2 million and each owner collects 2 million in selling price, not in profit, selling price, then they will withhold 7.5% of the selling price per person, proportional to your interest. So if husband and wife owns the property together, it needs to be 4 million rand before the withholding tax applies. It's not a final tax. You can get it back. And if you have all the detail, you can also get a directive beforehand. Okay, Carl, you can flip to the next one. Okay, very important now is that on the left-hand side, that disclaimer that American tax is extremely difficult. As I've alluded to you before, while you are a South African tax resident and the treaty deems you South African and you haven't got your green card yet, you will pay estate duty or federal estate tax on all the assets above 60 million rand. There will be no spousal rollover. And the minute you elect to be an American taxpayer on a worldwide basis, that exemption jumps up to 11 million. Furthermore, you then also have a exemption in terms of South African tax. But if there's an asset in South Africa, for example, that house in South Africa that you haven't sold, the treaty says South Africa can collect its 20% on that, and then America will collect the balance. Because remember, now you're in America on a worldwide basis, so they want 40% on everything above 11 million rand. But I think, remember, most people, you need 16 million to invest. And if it's the son that invested the 16 million or the 900,000 US dollars, then normally the parents would not have that amount of money left. And just remember, in South Africa now, at 30 million, our estate duty rate is 25%. So although I refer to 20, do remember that the people doing the EB5s are probably in the 25% range for everything in excess of 30 million rand. Don't forget that, okay? Then the assets that the Americans try to tax, I can't see it exactly on my slide, but there it is. So just important is that, don't ask me why, I don't understand the logic, but it's been confirmed. I've done a few estates like that. US cash in a US bank is excluded from federal estate tax if you live in South Africa, okay? So it is only the property that you own within the LLC or the American shares that will be included. We've had one recent case, which is now going to court very soon, which I think was quite unfair, but that's how the Americans interpret it. If you have American dollars in Bank of America in South Africa, and you die in America as a green card holder, that cash is included in the 40%. Okay, so whilst US cash in a US bank is excluded, it seems that US cash in a US branch of a bank outside America is included. So that's not on that slide, but that's just from a practical experience. So it's very important that you make sure that if you are investing in a EB5 project, that you know and exactly track through Leon's help where your money is lying, and your will must be adjusted according to that during that process, you must review every step, every change you have, you review your will. Because while the money is lying in cash, while they're doing the source of fund test, you in cash, no FET. The minute it goes from Leon into Carl's project, then it is subject to American estate duty, even if you haven't got your green card yet. The minute you are granted your green card, because 11 million is the exemption, 11 million US dollars, you've only invested 900,000, then you're out of it. So there is a very small period that can happen. And my poor client that I'm referring to with his dollars in the Bank of America branch or corresponding branch in South Africa, he died in between that period before he got his green card, but his money was already invested. So the minute they knew that he was over $60,000, the entire estate had to be registered with an executor in America. And Leon, as an attorney there, will tell us quite
Seems as though we lost Yuhu there for a little bit.
Yep. Okay, so I think what we can do now is look at some questions, if there's any questions.
Thank you very much, Yuhu. That was excellent. I see we have had quite a bunch of questions. Most of them have been answered already. Maybe one question I can address initially is, how secure is your money in this project? As Leon mentioned, one of the requirements is that the investment has to remain at risk. That doesn't mean it has to be risky. And obviously we ensure that the money is as safe as possible without jeopardizing that requirement. And the most important criteria really is picking the right counterparty that you're lending the money to, making sure that they have a track record, they have a high credit quality, and they have the ability to repay. You know, certainly IRG in this case has a tremendous track record, you know, over many years of raising EB5 capital and repaying that to investors. So we feel, you know, very comfortable in terms of partnering with them on this project, and, you know, a high confidence that you'll get your money back, as 70% of the EB5 investors that have invested through them have already got their full their loan repaid. Do you, there's another question here maybe for you, Yuhu. Do you still need a locked account to withdraw your annuity funds from South Africa?
No. So interesting. It's a very, very practical question. I think that's probably one of my existing clients who've seen us use that benefit. If I go back to the example, I'm doing all Leon sales work for him today. But go back to the example of the son getting the green card. He then brings his parents over, and they can effectively go and live in America on the B1, B2 visa. That's the visitor's visa. They then are not allowed to work in America, but remember, they're retired, they have adequate funds, they need not work. They can then elect to become American tax residents, because after 3 years and 183 days in that 3 years, not in a year, in that 3 years, they've been there 183 years, now they're American tax citizens, and they pay American tax on worldwide. They can then exit the South African tax system. They can claim their pay-as-you-earn back on most of the living annuities or life annuities, except the bought annuities. It's a very difficult concept, but those that you bought. But those that are true retirement funds, you can get your pay-as-you-earn back. Only America will tax you. And very interesting, in 2014, April 2014, Circular 4 of 2014 reads that when a pension fund pays a pension or a living annuity, the annual amount or the quarterly or half-yearly amount, to a South African who has not formally immigrated, so there's no need to formally immigrate, to a bank account in a foreign country, provided they have evidence that that person lives in that foreign country, that money can leave without tax clearance and without impacting your 1 million or 10 millions. So it's indeed a very, very attractive solution for the parents then to buy substantial retirement annuities. And there's a participant here, Kobus Klein, can probably tell you all about that. You buy a huge living annuity if that is the certainty you want, if you want that fixed investment lifestyle. That money then gets paid to you. America taxes you very lightly on that. South Africa has to exempt you. And that money then can leave South Africa, because on a living annuity and a retirement fund that pays out, you normally nominated the surviving spouse as the next recipient, or the children that's already out there. So most people see that as a very attractive method to get money legitimately out of the country. The other way that South Africans, while we're on that topic, for the Americans, South Africans with the parents living in America, buying sea containers, you can use South African rands, no tax clearance. The Reserve Bank says the income on the sea containers can then go to America without tax clearance. You still probably pay tax in South Africa on it, not so tax efficient, but it's a hard currency, legitimate way to get your return on capital legally outside South Africa. So the two ways that parents, elderly parents, finance their lifestyle in America is sea containers and a South African retirement funding or living annuity product.
Leon, this is a question you've actually answered, but might be worthwhile for everyone else. Can a parent with the US citizenship sponsor a child over 21?
Yeah, the short answer is yes. It just depends on if that child is married or not married. I think I looked up the dates, and if the child is married, it's like a 12-year wait. If the child is not married, then the wait is, I think, something on 8 years or something. I think is what I said.
Carl, can I just ask on that question about someone asked about the CITES tax, and they wrote CITES, but I think it's meant CITES tax. Very practical question. When you're in cash or in bonds or loans, then there's no FET on that money. But if it's an equities or fixed property, it is subject to FET. When you make this advance to the Hall of Fame project, if I can call it that, is that registered as a bond or a loan, or is it an equity? What is your recipient? What do you get back? What do you hold in your hand? Is it a loan certificate or a deposit certificate or an equity?
It's a mezzanine loan, but you're actually investing as a limiter into a fund that then lends the money to the developer. So you don't have a loan certificate or anything like that. You're just a limited partner in a fund, and the fund lends the money. That's pretty much standard how most EB5 projects are structured. We, as the EB5 firm, we're the general partner, so we oversee, we structure the transaction, and we ensure that our fiduciary role to ensure that that money is, the obligations are met and the loan is repaid. But you're a limited partner investor as an EB5 investor. You're a limited partner investor into a fund.
And that is then subject to FET, because you now have a business interest in the US. It's no longer a loan.
Well, I think that's pretty much answered all the questions. That's excellent. Thank you very much, Leon, and thank you very much, Hugo. I think this is great. We should consider starting a little LLC here, Van der Merwe, Versveld and Van Zyl, to help with all your US immigration needs.
After you mentioned the other day, I just thought we must be very careful, because I had one client that had a triple V in their business name, a law firm, and then unbeknown to them, the way that it came out in the early days of cell phones, it looked like a swastika. So they had to change their initials and their logo very quickly. So I've learned with a V, you just stay away with it. And Z is even worse, because the Z is even closer to the swastika. So it's a very, very, we'll go for the Hugo Versveld. HHV sounds a bit easier.
Excellent.
Just for those who are still listening, that Carl had up there is a local South African number. So the 010-500-95335 is a number that rings here in the US. So we are typically 7 hours behind you. More than welcome to pick up the phone there locally. It's a local call, or otherwise you can always email us at eb5@versveldlaw.com if you had any other questions that we can answer with regards to the EB5 program.
Excellent. Thank you. Thank you all.
Thank you, everybody.
Thanks, everybody. Thanks for hosting, and thank you, Carl. Thank you, Leon. Thanks. Bye.
Tot ziens.